we'll get started. My name is Diana from the Aging and Disability Resource Center. Our speaker today is Jessica, and she is the managing attorney of the Guardianship Support Center at the Greater Wisconsin area on aging resources. She's an area Milwaukee native and attended college at UW-Eau Claire and law school at Hamline University School of Law in St. Paul, Minnesota. Jessica has been practicing attorney for 10 years and practicing mainly in La Crosse, Vernon, and Monroe counties where she ran her own solo practice. Jessica will talk about legal decision-making and advanced directives in Wisconsin, including power of attorneys, living wills, and guardianships. Let's welcome Jessica.
Thank you everyone for coming. My name is Jessica, and can I just get by a show of hands, just curious how many are here in a professional capacity for their work, and then how many are here for information for themselves or for friends or family. So people here in a professional capacity, okay, and then here for friends, family, health information. Okay, great, thank you. So I'm going to talk about basically legal decision making in Wisconsin, and I'm going to talk about kind of why, especially in Wisconsin, this is particularly important, that we have advanced planning and then situations where guardianship is needed. So I'll kind of give an overview of these, and then I'll go through more of the specifics in detail. It is kind of a lot of information too, just to warn you. We do have a website, and that's listed at the end in the slides. So we have publications on each of these topics. We have tons of publications on guardianships. We have DIY, do-it-yourself publications on power of attorney healthcare, finances, and overviews. So if it's a lot of information and you want more information later, you can certainly email me, leave me a message on the helpline, or again, go to our website to get some more information. So again, it will be a lot of information, but there's definitely resources out there. So it's not like you have to memorize it or try to write everything down today. So I'll kind of start with this, and so I've said this before, and people actually gasp because they don't realize that Wisconsin is not a next of kin state. So that basically means in Wisconsin, just because you have a legal relationship to someone, you're their spouse, you're a parent of an adult child, that doesn't give you any authority to make decisions. So this is why, especially in Wisconsin, it's important to do advanced planning like powers of attorney. There are certain states where they do have next of kin, so if you don't have planning in place, they have a list of hierarchy in their statutes of who can make decisions for you in the event you become incapacitated. We don't have that in Wisconsin, so if you don't have, for example, power of attorney healthcare, you're in a car accident, become incapacitated, the only legal decision-making option would be for someone to go to court and get a guardianship, which can be stressful and it can be expensive, and sometimes it can take a while to get the court order in that situation. So in Wisconsin, there's different ways where we get legal authority to make decisions for someone else, and that's either the person has given you that authority or the court has given it. So from a person, it's like a power of attorney. You can basically think of that as a contract. Again, I'll go through that in more detail, what the power of attorney actually is. Or some people authorize a representative to help them manage a benefit. Or it can come from a court. So that's the guardianship. Guardianship is always a court process. So sometimes when people call me, I manage the helpline, the Guardianship Support Center helpline. So people from throughout the state can call. We are a neutral source, so I provide information based on the statutes and case law. So one of the first questions I ask is when people tell me they're guardian, I say, did you go to court? Because sometimes people use that term, or they were obviously the guardian of their minor children, and then they've turned 18, their children have a disability. They continue to call themselves the guardian. And that can get really confusing in certain circumstances, and some people will take them at their word that they're guardian. So I always kind of ask, did you go to court? Because usually people remember if they went to court or not. Or a conservatorship, so that is another court action where someone agrees to have someone handle their finances. So it may not be someone who's incompetent to manage their finances. They might have issues where they would just rather have someone else do that, but they also want court oversight. So that would also be a court action. Or a personal representative or an executor, basically someone that's named in a will. So those are kind of, in general, where we get our authority from in Wisconsin, either from the person directly or from the court. So I'm going to go through an overview, you can read that, and then again I'll go through some of these in more detail as I go throughout the presentation. So these are kind of the tools or the options that we have available to us in Wisconsin. So obviously anyone could sign a release form. You probably had to do this some point in your life. As an attorney, I've had clients sign these fairly often if I needed to access their medical records, things like that. But if you wanted someone to basically assist you or get access to your records, usually for the banks, for HIPAA, healthcare, and for educational. So you could just sign a release and you can put a date on when that expires, and then that person could talk to your doctor, or they could get some of your records, that sort of thing. Supported decision-making agreements, I'm not going to talk about that much today. I'll just go over it generally. This is new in Wisconsin. It was just signed into law in April. And so this is a less restrictive alternative to guardianship that must now be considered. So individuals that might just need a little bit of assistance in making decisions, they don't necessarily need that decision-making ability taken away from them. They can execute an agreement. There is a state form for this. It's called the Supported Decision-Making Agreement form. That is on the state website for the Department of Health Services. So they can name a supporter, and it's in areas like education, housing, medical, that sort of thing. And they can have the supporter just assist them with decisions, help them obtain information, and that can't basically be used as any evidence that they are incompetent or incapacitated. So if there's an individual who might just need a little extra assistance, a little extra help, but they might not need a guardianship or a full guardianship, then supported decision-making agreements can be considered. There's the representative payee, so that's just managing Social Security benefits, and any changes, modifications, appointments have to go through Social Security, so that's not something that goes through the local court. Then we have the power of attorney, so this is, again, is basically a contract, and an agent, or a principal, the person doing the agreement, designates an agent to make decisions for them, and I'll go through those in much more detail. There's different ways that they can be set up or activated. Then the limited or full guardianship. So we have a presumption in Wisconsin that if there is going to be a guardianship, that it be as limited and less restrictive as possible. Unfortunately, in practice, sometimes people end up with full guardianships. I think the last statistic I heard was about 90% of people end up with a full guardianship, which means that all of their rights have been removed in the guardianship action. There's always going to be some rights that people retain, but the rights specifically at issue in the guardianship action have all been removed. Other individuals might have a more limited guardianship, so they might still be able to make some decisions in that process. So for example, the right to vote, the right to execute a will, the right to serve on a jury, those are types of rights that we see in a guardianship action. So you could have someone who has actually been determined to be incompetent by the court, yet they can still execute a will. They're still of sound mind to execute a will. So they might have a more limited guardianship. It depends on each person's circumstances. And again, I'll go through guardianship in much more detail. So these are, since it is a continuum in a little bit, where you see guardianship is really the most restrictive option that we have in Wisconsin, where people can lose significant rights. So we have to also look at what are less restrictive alternatives to guardianship, and this is where it kind of, it flows very nice. We're talking about powers of attorney, supported decision-making, and guardianship as well. So these are the types of things in Wisconsin that we're required to consider before we impose a full guardianship on someone or any sort of guardianship. So any sort of training, education, support services, assisted devices, advanced planning like powers of attorney, trusts, having a representative payee through Social Security. The court forms allow any other option, and then again, supported decision-making now has to be considered as an alternative as well. So I'll kind of start with one of the first alternatives that's more widely used would be power of attorney. So again, this is a legal contract, and so the person who's executing, who's signing that document, they are called the principal. They're giving a chosen person, their agent, authority to act on their behalf. And I'll go through the differences between financial and healthcare. And then the agent really has to act in accordance with their wishes. So when you're considering who you want as your agent, you want someone that you can trust, someone that's going to be dependable, someone that can work with professionals, and someone that's going to be able to honor your wishes. So if you have someone that has completely different principles and values as you, then you may not want to name them as your agent if you don't think that they can follow your wishes. So in general, the types of powers of attorney that we have in Wisconsin are for finances and property and then healthcare. And they're pretty much what they sound like. So for finances, it's things like a person could pay your bills for you. Well, not for you, on your behalf, that would be nice. They could, I'm gonna use my power of attorney and you have to pay my bills for me. I want one of those. So they can pay your bills for you with your own money. They could file taxes for you, sign your taxes, balance your checkbook, managing insurance. So a lot of people think of insurance as healthcare. So if you have Medicare, Medicaid, private insurance, it's actually going to be a power of attorney for finance that is managing any insurance. So some people will say, well, I don't need a power of attorney in finance because I don't have any property, I only have Social Security income, and I don't really have any other needs. But most people are probably going to have to file taxes, they're going to have some sort of insurance application, reapplication, that sort of thing. So a lot of people will still need a power of attorney for finance. It's also things like signing contracts or leases, so that can come in handy too if you have that. Again, if you don't have a power of attorney in finance and you end up being incapacitated, the other option is really a guardianship of the estate. There are certain powers that you can give your agent, but you have to specifically state that in the document. So if you wanted to be able to have them gift, that sort of thing. So my parents are in their 70s and they have 3 grandkids and they have educational accounts for their grandkids, and I'm their power of attorney agent. Not acting right now, but if they wanted me to continue to be able to contribute to those AdVest accounts, they would have to give me that specific authority in their power of attorney. Otherwise, I would not be able to contribute in the event that they were not able. So the power of attorney finance is actually typically active right away, so right when you sign that. It's not actually required to be notarized or witnessed. We highly, highly recommend that you have it notarized. There's additional protections for banks and financial institutions in the statute if it's notarized. So you're probably going to have a difficult time, even though it's technically valid. If it's not notarized, the bank might not want to accept it, and then you have those additional protections for you and the bank in the statute. So some individuals do have their financial active upon an incapacity. The old form used to have check boxes. The old state form used to have check boxes for how you wanted it activated. Now the default is that basically you sign it, it's active. They can manage your finances, they can sell your property. So for some people, they do it out of convenience with their spouse. They want their spouse to be able to do that without them signing off. Or they're going to be out of the country, they travel frequently. And you might have had this too. My parents have this all the time. They've been married for 50 years. My dad hates making phone calls, so my mom has to make all his calls for him. And the person on the other end will say, well, where's your power of attorney? It doesn't matter that they've been married for 50 years. You can also have sometimes, like my dad does in the background, he says, that's fine, you can talk to my wife. So you can give permission, or you'd have to send in your power of attorney for finance. So some people do have them active right away. That's the default in the state form, and again, some people do that for a matter of convenience. That just works for their needs at the time. I did have one in private practice where there was a minor guardianship, and the grandparents were applying to be guardians of their grandchildren, and one of the grandparents was active military and he was stationed elsewhere. So he actually did a power of attorney so that his wife could basically represent him and sign anything that we needed for him as part of the guardianship action. So there can be different uses for powers of attorney. Is there a question? Yes.
Yeah, we have a power of attorney, my husband and I, for each other. And the insurance company, life insurance company, would not accept finance. So I would suggest people add life insurance in addition to finance, because they would not accept the power of attorney.
Yeah, for some things there's very specific designations or grants of authority that you have to give in the power of attorney. So changes to insurance sometimes are like that, like if you want to change a beneficiary designation, that sort of thing, you need a special grant of authority. And so in our publication on our website too, it kind of goes through the list of, and you'll see it, you can see in the state form there's check boxes for taxes, real property, which would be like a house, that sort of thing, insurance, and if you want, again, any special grant of authority, you can look up our publication and it will list those things. But things like changing insurance might be one of those, especially if you change beneficiaries. Yes?
That can also be done at a bank sometimes. They have the authority to grant a signature that an insurance company will accept.
So just to clarify, for a financial power of attorney, it does not need to be notarized for it to be valid?
It does not. It's not a requirement in the statute, but the banks might not accept it, even though it's technically valid to not even have that notarized. If the person signs it, there's no witnesses, there's no notary, it's valid. There's additional protections for the bank if it's been notarized. And then there's kind of a procedure, if they challenge it, then a procedure to go through. Yes?
Doesn't the statute actually say that there's only a presumption of validity if it's been notarized?
Yes. They presume the signature is valid.
If it's been notarized.
Right. Yeah. Yep.
So that person that you give the power to, they can do anything, but they can't do it until you're incapacitated, or?
For finance, it depends on how you do it. The default for the state form is they would be able to do that right away unless you put in the special instructions that it's active on an incapacity only. And for financial, if you don't further define that, it's active by one physician would basically sign a statement of incapacity. Tell you medical professionals are not that used to doing that, but the language is right in the statute, so I get questions on that fairly often of, is there a form for that, or our doctors don't feel comfortable evaluating that for the ability to make financial decisions or not. But the standard's right in the statute that it would be active by one physician's statement if you decided to do it that way. So if you have really complex estate or anything like that, or you want it drafted in a particular way, it's not required that you see an attorney, but they would be able to draft that for you as well to meet your needs if the state form doesn't work for you. For financial, 2 co-agents are allowed, so you could have 2 people at the same time. The default is that they would be able to act independently. We recommend that you don't do that you name a primary agent and then someone that could be an alternate or successor if they are ever unable to act. Again, you could have 2 agents at the same time, and if they're acting independently, they might think that the other person, oh, I thought you paid that for mom, or I thought you filed mom's taxes. Whereas if you arrange it so that you have to have 2 signing at the same time, you can see where that would be a problem too. If you have to, every time you sign a check or you sign anything, you have to have both agents sign. So some people, they don't want to hurt anyone's feelings. They might have 2 children and they don't want to pick anyone, and so they put both, and then it's probably going to end up causing more problems than it's going to be helpful. But it is an option if people want to structure it that way. Yes?
Who do you recommend should have copies of that? Because it's such an independent contract.
Right.
You know, like in healthcare, you can put that at the hospital, you give it to your doctor. Who gets that?
I mean, you can give it to the banks and any companies that would require it, like the insurance company, that sort of thing. You should keep a copy for yourself in a safe, accessible area. Some people put a card in their wallet saying I have powers of attorney, here's where they're located. So you should have a copy for yourself, copies to the agents, and then any financial institutions, insurance that might need it, that sort of thing. So for power of attorney healthcare, this is things obviously like making healthcare decisions. Things like, I'll go through this a little bit more, but admission to like a nursing home or assisted living, that needs a very specific grant of authority. Any end-of-life care, and again, I'll be talking about the difference between power of attorney and living will, and that gets into more of the end-of-life care. Deciding between different treatment options, surgery. And so this is a little bit different. So typically, again, this is based on the state form or how most people do it. It's active upon an incapacity. So you could name your adult child as your agent, and they might not act for 10 years under your power of attorney health care. That's typically how most people do it. It can be structured in a different way if you want it to be done, but most people, if they have capacity, make their own decisions, they're going to want to. And that's 2 physicians or a physician and a psychologist that sign a statement or a certification of incapacity to make healthcare decisions. And there's no state form for that, so the facilities use their own form, and that's done fairly frequently. It's also just an incapacity to make healthcare decisions, so your agent's only able to make healthcare decisions for you. So it's kind of like all these puzzle pieces together. It depends a lot on your own needs. But again, if you just have the power of attorney for healthcare, which a lot of people have those because every time they go to see the doctor, they might be asking you to do that. So just consider that. Yes?
Did you say incapacity is 1 doctor or 2? Have to say your.
It's 2 for the healthcare and 1 for the financial. Unless you could put in your financial that you want 2 physicians, but the default for financial would be 1 physician if you've drafted it that way, to be active upon incapacity. For healthcare, you do have to be of sound mind to execute. There's no exact standard for power of attorney finance in the statute. I think in general it's accepted that you have to have some sort of capacity or competency to enter in a financial power of attorney, and it's probably a little bit higher than sound mind. So sound mind is a very, very low standard. It's basically the person can kind of generally understand the document, indicate what they would want, they can sign it or direct someone else to sign that for them, and they can kind of understand what authority they're giving. So you can actually have an activated power of attorney healthcare. So you could have an incapacity to make healthcare decisions, yet you could still be of sound mind to decide who you would want to make those decisions for you. So that is really, really a case-by-case determination. And who's going to basically determine this is your witnesses. So you do need 2 disinterested witnesses for power of attorney healthcare. That means they're not a relative, they're not your healthcare provider, they're not an employee of your healthcare provider unless it's the chaplain or the social worker at the hospital or the clinic. They have no stake in your healthcare or your estate, basically. They're not related to you in any way. So people use friends or neighbors as disinterested witnesses. It's our position really that you should not have co-agents on a power of attorney healthcare. It is kind of a gray area. The statute doesn't really say anything about it. Like financial, it specifically indicates that you can have co-agents. It's silent on that. You can see where this would probably be a huge mess, especially for healthcare or an emergency decision needs to be made, and you name 2 people. So I have this fairly often. Sometimes people will name 3 people and they'll say, Joe and or Sue and or Mary, and then they call me and they're like, well, what should we do? Who makes the decision? So you always want to avoid any confusion. So I think it's best just to have your agent and then name a successor or an alternate if your primary is ever unable or unwilling to act. So again, we kind of have to think of this. People can get kind of confused on this because especially after like a power of attorney healthcare has been activated, they're like, well, they're incapacitated. So it's really, you only have this authority as agent because it's been given to you. So even after an incapacity, the agent has to follow any express wishes of the principal. This is sometimes why we need guardianship as well, because the agents are limited in their authority. They can't force treatments on someone even if it may be in their best interest. They also can't force any sort of like nursing home or assisted living placement if the person is refusing. So they really should be always following the wishes of the principal, and they can express that at any time, even after an incapacity. If their wishes are just unknown, or they might be in a coma and they didn't talk with you before about their wishes, you can make decisions based on a best interest standard. But again, you can never basically put your own opinion, make decisions based on your own opinion. So if someone's an agent for their parent and their parent's been very specific about a course of treatment or stopping a course of treatment, and then their power of attorney is activated, that power of attorney can't say like, I'm in charge now, so like load her up, let's do the full game here. So they have to basically follow it, especially if that's been documented and they've made their wishes well known. So I get lots of questions with powers of attorney possibly exceeding authority. It's also things like they might be restricting visitors, and they might be saying you can't drink or you can't smoke, you can't do this. That's not really a healthcare decision. Healthcare decision is basically what doctor should they have, what medication, should they have this surgery, that sort of thing. I get this question actually a lot. So people make changes to the actual document. Again, this is kind of, there's nothing clear on this. So a lot of facilities just won't accept it, or they'll say it's invalid if there's any changes made to the document. So once it's signed, don't make any changes to the actual document. If you have to update someone's phone number, your agent's phone number, if they got married and they have a new last name, you can put a sticky note on. You can write something to everyone that has a copy, just updating them with that information, but don't make changes on the document. I did have someone call in, and it is a well-known hospital, and they had crossed off a number and updated a number, and the hospital was like, no, we're not accepting this, it's not valid, because there was changes made to it. And sometimes people will cross it out, will initial it, but it's like we don't know when that was done. So again, best thing, don't have anyone question your power of attorney. So just don't make any changes to the face of it because it could invalidate that. Individual can revoke their power of attorney at any time. Again, this is kind of based on you gave the authority, and so you can revoke it at any time, even after there's been an incapacity. So if individuals do that, and people will call me with that question too, they may not be happy with their agent, they might be incapacitated, and if they tear that up or they burn it, they might need a guardian. But that's their decision to revoke the power of attorney, so they can do that at any time. You can write a short statement revoking that, and then it's helpful to provide copies of that to everyone that has a copy. Again, you actually can burn your power of attorney, that's a proper revocation, but if nobody knows that you did that, they're all still relying on the copies. So if you do it in any of those ways, you just want to make sure to notify your agents and everyone, like the healthcare providers, that have a copy of it. You can have multiple powers of attorney financed at the same time. It doesn't automatically revoke your old power of attorney, because someone might have an agent to sell their property and they might have an agent to do their taxes or something like that, so they can be for different purposes. If you execute a new power of attorney, it does revoke the prior power of attorney. And there are situations where it's like, oh man, like mom has like 3 powers of attorney floating out there. Depending on who they're with, they have them keep doing new powers of attorney. So it's basically whatever is dated last, as long as it's valid, validly done, and they're of sound mind, and that would be the current power of attorney healthcare. If it's kind of back and forth like that, again, they might end up with a guardianship if it's so contentious. Yes?
Could you create some kind of document that would allow some other person to act in your behalf as the power of attorney, say if you were unavailable?
No. It has to be someone that was actually named in the document. So this is where it can be helpful to have alternates too, because if someone is on vacation, then the alternate can temporarily step up and act and perform the duties, but it has to be someone named in the document. So it happens sometimes too where someone might not be of sound mind to execute a new power of attorney, and the agents they named have either all passed away or they don't want to act as agent, and then again the only option would be for a guardianship if they can't execute a new one. But the power of attorney for healthcare can't basically delegate their authority. I believe the financial can, but I think you have to have a specific grant of authority in the document.
So what if that person can't? I'm in a situation where I'm a caregiver and the power of attorney for the medical power of attorney is not always available. But I had to take the person to the doctor, to urgent care, there's nothing that, all I can do is just try my best to get hold of that person.
I mean, they can certainly have someone help, like they can have you take them to the doctor's appointments. It's just nobody else can make any decisions unless they've been named in that document. And so when you're thinking about, if you haven't done it or if you have them and you want to go back and review them, you want to think of people that are accessible, that you can get a hold of, that are reachable. It could be someone who's not in the state. It doesn't have to be a family member either. So if you have someone that's dependable and accessible, then that might be someone that's good to choose. If it's someone that is kind of unreliable or hard to get a hold of, they're probably going to continue to have those issues. Sometimes if the power of attorney agent, they just can't get a hold of them, someone might end up filing for guardianship. So the point of doing the powers of attorney is kind of hopefully that they're advanced planning and you avoid going to court. There is basically procedure, some safeguard if that agent is exceeding their authority. So you can do that under the financial or the healthcare. So basically the court can review the power of attorney, they could revoke it, they could require the power of attorney to come and report at specific times. So there is some safeguards. I'll mention this a little bit later, but there is the Elder Rights Project with either Legal Action or Judicare, so I have their information on the resource slide. And so they can do things like they would have attorneys, if there is an abusive power of attorney that needs to be revoked, they could potentially bring that to court for someone as well. So the power of attorney is usually sufficient. There's hopefully no court involvement. There's no cost to that. Again, you can see an attorney if you want, but there are state forms and those are all available online on the Department of Health Services website or my website, which is on the slides as well. You're picking your agents, you're picking your decision maker and deciding what decisions they can make, and you indicate what your wishes are. But obviously, there are people that have guardianships, and so sometimes they're needed even if there is advanced planning. So if someone does need nursing home placement, and they're refusing, the power of attorney can't keep them there. They can't have anyone in a locked unit, you would have to have a court order for that, they can't write a will. Again, things like changing beneficiary designations, having a special needs trust established, you have to have specific authority in the document for that. So sometimes if a person can't do that, but they have a need for that, then the only other way to do that on behalf of someone would be to get a guardianship. Again, they can't make any decisions the principal doesn't agree with. Another important thing to kind of review on the power of attorney document, and this is why a lot of guardianships end up being filed, there's a section where you would authorize your agent to allow admission into, it's called a CDRF, it's an assisted living, it's a community-based residential facility or a nursing home. And so there's a yes or no section there that would be for long-term placement. And some people, I've had someone that called in and their mom checked yes for nursing home and no for CDRF because she was like, I don't know what that means, so I'm gonna check no. So she stayed in a nursing home even though she could have gone to an assisted living because she didn't check the box because she didn't know what that meant. So it's not saying that you want to go there, it's just giving them the authority to admit you in the event that ever was a need. So there can be a lot of issues with that, with the need for guardianship and protective placement. An agent also cannot always protect from abuse, exploitation, or self-neglect. This is sometimes when Adult Protective Services for the county might get involved and file a petition through their corporation counsel or county attorney. So there are limitations of the principal. They could do things like file restraining orders, that sort of thing. Again, with the financial power of attorney, if you just do it the default way, it's active upon signing, you never lose your ability to manage your finances. So some people that might have issues with financial exploitation, and you can't really restrict their ability to access their own funds, you might need a guardian for that as well. Briefly talk about living will, and there is a chart, I don't expect you to be able to read this, but I just wanted to put it in there so that you can see that this is on our website too, so it gives a comparison of power of attorney, healthcare, and living will. So a living will is basically a declaration to physician, so that's instructions to your physician. You're not naming any agents. You do, again, have to be of sound mind, and it has to be done voluntarily. It goes into effect in very, very limited circumstances. You have to have 2 disinterested witnesses again. The power of attorney healthcare is actually broader, so all of this can be encompassed in your power of attorney healthcare. You don't necessarily need both documents. The situations where I've seen this come in handy is if someone has a power of attorney and a living will and all their agents have passed away. There's at least now a document that instructs the doctor on their end-of-life wishes. Or there's individuals who, unfortunately, they don't have anybody to name as agent. They want to do advanced planning, but they have either they don't have anyone in their life or no one that would be suitable or appropriate to be their agent. And so then I say, well, at least they can do a living will, so there's a legal document that shows what their wishes are. If they end up needing a guardian in the future, then at least the guardian also has an indication of what they would want. If they do have both and they're inconsistent, the power of attorney healthcare is going to be the one that basically trumps. So this is when the living will applies, yes.
If you have a will laid out, and you have 2 people sign it, and one happens to die, how does that work?
So I should back up too. So a living will is something that applies when you're alive, basically. An actual will is how you want your property or your assets to be distributed after you pass. So I don't get in anything about like estate planning in that nature or wills or anything like that that would go through probate in that regard.
Once you have a will made, can you update it or add to it without going to a lawyer?
So I don't get into issues with wills, so that's not part of basically my grant or what I can talk about. But I'm glad you brought that up because I should make that distinction between the living will and a will. I can say you basically have to be of sound mind to do the will, and so you can make changes if you're still of sound mind to do so.
But then you have to have it like notarized or go back to the lawyer?
Yeah, I'm not going to get into that.
Okay.
But I'm glad you brought that up so that I can make sure to make the distinction between wills and living wills. That does get confused frequently as well. So the living will is basically only applies, so again, you could execute this and it's not used for 10 years. It's only for basically life-sustaining procedures, so that's hydration, nutrition, feeding tubes, that sort of thing, or feeding tubes. So basically, the life-sustaining procedures mean it's prolonging death. So you're in a situation where you're not going to have a recovery, any feeding, hydration, nutrition, it's just prolonging the death. You have to be a qualified patient, so basically this is when you have a terminal illness and death is imminent. I know this is really like uplifting stuff. Or you're in a persistent vegetative state, and that's determined by 2 physicians. So again, the living will only specifically applies to end-of-life wishes in these very specific circumstances. And again, all of these advanced directives, the power of attorney, living will, there is, I'll just mention this very briefly, not to confuse you even more, but there is an authorization for final disposition to make things even more cheery about your funeral and how you want that handled and who you want to make those decisions. So if you have that document done, you can name who you want to be your representative to carry out your wishes for your funeral. Otherwise, it goes through a list of basically family or kind of at the end, anyone that we can find that's willing to do this. So at least that gives you the choice of who you would want to do that. So all of these forms are online or on our website, PHS or our website. So again, this is just the overview, and again, I don't expect, maybe I'll ask the person right in the back, what's this word talking? So I don't expect you to be able to read it, but I just want you to be aware that there is this chart out here, because it can be kind of confusing with all the different documents and requirements. So I think that's a really good slide that gives a comparison of the living will and the power of attorney for healthcare. Yes?
Going back to power of attorney for healthcare, if it's not activated, you're able to sign your own paperwork, your own releases, stuff like that, but if it's activated, is somebody able to sign any of their own, like, release of information, or?
It would be the agent that would sign once it's activated.
So you wouldn't be able to sign your own, the agent would have to sign everything?
Yeah, for any healthcare decisions.
What about hospitalization?
That would be the agent would be making any healthcare decisions once it's been activated. Yes?
If they're not incapacitated, can the POA sign like paperwork at all if like they are saying they want them to? Or does it have to be activated?
It really should be activated. People can draft their powers of attorney in different ways. Some people have their power of attorney healthcare activated right away. It is in the statute that if the person is not incapacitated, that their wishes are always going to trump whatever's in the document. So they could do it that way. They could say this is active right away. I want my agent to make decisions before I'm incapacitated. There's a lot of confusion when people do it that way. But the agent could technically sign or that instance, but if they ever didn't agree with them or there was something in the document that's contrary to what they're saying, their wishes, you have to go by what the person is saying. Yep.
So back to the example where you said somebody checked the yes to a nursing home admit but no to CVRF. If they say no, there's no way around it, like you can't petition a court and say this is a better thing for them or anything, and no means no?
You can with the guardianship and protected placement. That's a lot of fun. So for protected placement, you need a doctor's evaluation and a social worker's evaluation. It has to be the least restrictive placement. They have to have a permanent condition or likely to become permanent. They have to have a need for residential care and custody. They can fight that. They can have a jury trial. So if they have checked no, the only way to basically admit them to that facility, if it's over 16 beds, is through the court order. So there's certain circumstances where there's a guardian already in place. They can do temporary placements, or a family member that lives with the individual can have a respite placement, but that's only short term. So for any long-term placement, if they check no, especially if they're actively refusing, you're going to have to get that court order, and they can contest that. They have the right to have an annual review of their protected placement, or what's called a WATS review. So every year they can basically contest that and have a due process hearing on whether or not they should continue to be protectively placed. So that's why it's really important. Again, some people are like, heck no, I'm not going to a nursing home. And they've actually ended up just costing themselves a lot of money too, because usually the cost for bringing the proceeding comes out of the individual's income and assets, as long as it's equitable to do so. So it's kind of the more that they fight, the more they're actually costing their own estate. So these can end up costing thousands of dollars. if someone just didn't check a box. If the person is still of sound mind and they're like, you know, they can redo their power of attorney and check yes, as long as they would be of sound mind to still do so.
So if the healthcare power of attorney's been activated and, like, so they've been declared incompetent, but you like take them to a facility and say, you know, hey mom, what do you think about living here? And what if they agree to it, even though they check no, but you don't tell them it's a CVRF? I mean, is that okay if they're still kind of agreeing to it?
You wouldn't be able to authorize admission without that. Sometimes there's issues where people aren't looking at the paperwork. I had someone who was in, I think it was a nursing home. It was definitely assisted living, over 16 beds at the very least. And they only had a copy of the power of attorney finance. And when they got a copy of the power of attorney healthcare, it said no, which is a big problem.
Okay.
Yeah, so there's no other way to admit them again unless they're able to redo their power of attorney if they're of sound mind to do so, and that's going to be a case-by-case determination. It's not required, but if they have an activated power of attorney, it can be helpful if there's a doctor that can kind of weigh in on that, or having a social worker as a witness, because that is an exception if they work at the hospital. So you could kind of have them as a witness, they're going to document it, and then have a doctor's opinion. A lot of attorneys that do elder law or work with individuals with diminished capacity, they're probably going to they're going to want an evaluation from a physician before they would draft something and have someone sign that. So there could be, I guess, a way to do that as long as they're still capable of doing the power of attorney healthcare. Even if someone checked yes on those and now they're refusing, now they have dementia and they may not understand their needs or they just don't want to go there, even if they authorize that on the power of attorney document, you still need a protective placement if someone's protesting at that point.
Thank you.
Yeah.
Could you change the residency from the state?
It depends. So I can only tell you how Wisconsin does it. So if someone from Wisconsin or someone comes from out of state to Wisconsin, we recognize out of state power of attorney. I can't tell you the reverse. It's probably different in every state. The problem is if we have the very specific protective placement language, and not every state has that, most don't. So like in Minnesota, I worked in La Crosse mainly, and so they're right over the river. And so you could place someone in Minnesota that's under a Wisconsin guardianship. They didn't need a protective placement order because they don't have the same protective placement system. So if someone, let's say from a different state comes into Wisconsin, they have their power of attorney, you recognize that, but if they don't have the language about admission, you're going to have to end up going to court if admission is needed. Of course, if someone is still capable, they can of course admit themselves as well to a facility if it's before an incapacity or a court determination of incompetence. So this is kind of an overview of when we end up with guardianship. So either there's no power of attorney or it was invalid. So check your powers of attorney too. If you have them, and if you don't, be sure to do them tonight. I get a lot of questions where the dates are actually wrong. So the witness and the principal signed on different dates, and that's pretty much going to be invalid. So you don't want to end up getting a guardianship for a family member or for yourself in the future just because someone put the wrong date down. So you have to have a valid power of attorney. Sometimes agents have just passed away or they're just no longer able to act, and so there's no decision maker and the person isn't capable of doing a new power of attorney. This is needed a lot of times. Again, adult protective services might get involved with abuse or exploitation, neglect. That includes self-neglect as well. There might be individuals who were never of sound mind. They were never able to complete a power of attorney healthcare. So when they turn 18, they're probably going to be under guardianship. There's no other option. Or someone needs additional authority. So again, like setting up a special needs trust, changing a beneficiary designation, potentially selling property if some of those boxes weren't checked, or they need authority to place. So a lot of my guardianships and protective placement in private practice, I worked with the county. I did a lot of guardian ad litem work. So I represented the best interests of the individual, the proposed ward that would be under guardianship. And this was when the power of attorney didn't authorize admission, things like that, or again, if they're refusing admission. So when you have both, basically the power of attorney can actually be kept in place. during the guardianship, and so the court could allow that to remain, and it will be the power of attorney that continues to act under that document, and then the guardian and kind of the additional areas of authority. Or the court can revoke the power of attorney completely. So sometimes it's the power of attorney agent that was committing the exploitation or abuse, and so the court's probably going to revoke the power of attorney in that situation. Sometimes maybe it's just a power of attorney that they didn't have any bad intentions, they probably had the best of intentions, but they just really can't meet the needs of the individual, and so maybe they just didn't get the paperwork in time, they ended up homeless, that sort of thing. So the court can also limit the power of attorney. They can appoint a guardian, could have the power of attorney still involved in limited ways.
Now, is this, when you're talking about the courts can revoke the POA or keep it in place, that has to be brought to the court by the person that needs the POA?
That's in the guardianship, so that would be like whoever is petitioning for the guardianship, so who's ever initiating that would be asking the court to do that, to revoke or limit the power of attorney. For some of them where we need the guardianship just for the protected placement, we'll probably keep the power of attorney in place, and a lot of the times it's the same person. There's a presumption that who's ever the power of attorney is going to be the guardian unless it's not in the individual's best interest. So I think a lot of times we don't see issues with that because it's the same person and they don't really know whether they're acting as power of attorney or guardian because they have authority under both. So everyone basically, every adult is presumed to be competent in Wisconsin once you turn 18. You can start a petition basically at 17 years and 9 months because it could take 90 days to get a hearing and an order. Guardianship is not an extension of parenthood, so the guardian is a legal relationship that's been created by the court. And again, only necessary when there's no less restrictive options. So I get a lot of questions on this too, the difference between incompetency and incapacity. So the incapacity is a standard for activating a power of attorney. Incompetency is a court standard, so that's actually a legal determination made by the judge. But you can see kind of part of it is the incapacity standard. So this is basically what you have to show in order for there to be a guardianship. So they have an incapacity, they have some sort of qualifying impairment or disability, which is listed there. So degenerative brain disorder would be something like dementia, Alzheimer's, that sort of thing. It can also be for mental illness, developmental disability, or other life incapacities. There also has to basically be the safety aspect. So there has to be some sort of risk of physical or financial harm. So they basically can't meet their own needs for health and safety. They're at risk of their property being dissipated. They're at risk of financial exploitation. So sometimes people want to file guardianship because it might make things easier for the one who wants to be decision maker. They're running into roadblocks in other areas, but it's really only when there's that additional safety factor there. And again, no less restrictive alternatives. Incompetency is not physical disability, just being old, eccentric. Had a lot of cases with eccentric people, and that's not why we did guardianship, but they can't just because you're eccentric, they can't say that you're incompetent. I always like those kinds of cases. Or just poor judgment, so I get questions on that a lot, like, oh, they're gonna make a bad decision, or we don't agree with that. So basically the court can't consider these to say someone is incompetent. It has to be the standards on the previous slide. There is a way to get a temporary guardianship. Again, it depends on the county. I'm not familiar with Dodge County. I've heard that some counties won't file or won't let people file temporary guardianships. In La Crosse, that was fairly common. You can get into court quicker. There are some limitations in the guardian authority, so guardian of the estate can't spend more than $2,000, that sort of thing. And then it would be good for 60 days. You can get an extension if there's good cause, but if you get an extension and you let it lapse, you lose your ability to file a new guardianship for the next 90 days. So you have to have that permanent hearing within either 60 days or 120 if you get the extension. So for the permanent, once you file, it should be heard within 90 days of filing in the court. This is important. The guardianships in Wisconsin never expire. So in some states they expire or they have reviews every year, every 3 years, every 10 years. We don't have reviews for just guardianship. We only have annual reviews if there's a protected placement. But individuals have the right to have theirs reviewed. It's just someone has to end up bringing that back to court. So you could potentially have someone as well for the younger generation who's put under guardianship when they're 18 and might never be reviewed for the rest of their life. I get those questions from banks or facilities sometimes where they're like, do we know if this paperwork's still valid? So again, they don't expire. It has to be changed or terminated by the court. So any modifications and changes have to go through and be approved by the judge.
Why would you want a temporary guardian?
Well, sometimes it's just there's a decision that needs to be made quicker and you can't wait 3 months for the guardian to have authority. In my experience, a lot of it was when there's emergency protected placements. So if you have someone who's wandering the streets or they're walking in the middle of the highway, I had someone who believed that there were diamonds and jewels buried all over the city, and so they would wander, and at first the family was able to kind of redirect them and get them back to the facility, but after a time they weren't able to do that, and so then there's going to be an emergency detention and a temporary guardianship. So a lot of times it's an emergency basis. It is a lower standard to get a temporary guardianship. I've had some individuals where the person's probably going to be passing away soon, and so they might try for a temporary guardianship because it's going to be cheaper. They're going to be able to accomplish what they want if the person's not going to live much longer. You might be taking a gamble with the timelines on that because, again, you would lose the ability to refile if you don't get a permanent hearing in time. So there is a guardian of the person and guardian of the estate, kind of similar to the powers of attorney, and they're pretty self-explanatory about what they can do. Again, it would be the guardian of the estate that's applying for the public benefits, signing a lease, and then guardian of the person is a little bit more extensive than power of attorney and healthcare. So it is things like social services, finding housing. It's not just medical decisions. It'd also be things about like making decisions about divorce, someone being allowed to get married, that sort of thing.
Doesn't spouse right to do all those things, a guardian?
Nope. So that's kind of where we started, so we're not a next of kin state. So no one, regardless of their legal relationship, has the ability to make decisions for another. If it's something like you have a joint account, so if you have joint account holders and 2 people, basically each person owns 100% of that account. So some of it's going to depend on how you have property titled. So for some marital property or again a joint account, someone could clean out the entire account if they're a joint account holder, because both people at the same time own 100% of that account. It's kind of interesting. Yeah, so it depends on how some of those are titled, but in general your spouse is not going to be able to sign for you unless you have the power of attorney or they're the guardian. So it's not that uncommon that the guardian ends up being the spouse.
So if you get a financial power of attorney and you give it to, say, one of your children, okay, they can pay your bills at any time for you or do any of that without you being incapacitated? Or do you have to be incapacitated? I mean, can they sell your house out for money?
They can, as your power of attorney. That's why some people do decide to have it on incapacity only. And obviously you're kind of going back to you want to pick someone that you trust so that that doesn't end up happening. But, you know, powers of attorney can be a great tool and a great advanced planning tool, but they can also be permission for, not permission, but they can give someone the ability to exploit individuals, which is where sometimes that's when guardianship is filed. I had a case where a family member stole $60,000 from an individual, and so they needed to file for guardianship to limit that person's access to them, so the guardian could control the money.
But yet if you became incapacitated where you couldn't manage your checkbook, then they'd have to prove that you're incapacitated to take it away from someone.
Right, for financial, typically it's one physician has signed a statement, unless you've indicated a different method in your power of attorney. So the guardianship standard, basically they can make decisions in your best interest. They give consideration and strong preference to what the ward wants, but they're not bound by what the ward wants. So that's different where the power of attorney has to follow what the principal is expressing. The guardian doesn't necessarily have to agree with the ward. They can make decisions in their best interest that the individual doesn't agree with. So in general, basically the guardian should not be restricting visitors, phone calls. So I've had a lot of questions on that where either the person doesn't have access to a phone or the guardian wants them to have a phone log and they can only talk to certain people. Under a guardianship, you still retain the constitutional right to associate with whoever you want. So that can be basically reviewed by the court as well. Everyone has the ability to access our advocacy agency, so that's the Board on Aging and Long-Term Care. If you're over 60 or in general under 59, Disability Rights Wisconsin. So both guardian of the estate and the person basically have duties, and these are all in the statute. So they really do have to incorporate the person as much as possible, basically integrate them into the community while considering safety and the needs and abilities of the person. So there can be a lot of pros to guardianship. One of it is that there's court oversight, so if there's a guardian of the estate, they have to do annual accountings. They have to do an initial inventory and then annual accountings. So you know that someone is basically looking over that. You could require your financial power of attorney to do accountings as well and submit that to the other agents. You have to put that in the instructions. So at least with that, you know that there is some oversight. And it is an option. I mean, we need guardianship when there's no other options available. They haven't done powers of attorney, or they're being exploited, that sort of thing. You have documents which clearly indicate what rights have been transferred, what authority has the guardian has. Sometimes people don't actually check the court paperwork, but hopefully they're checking it, and so the guardian's authority is clearly spelled out by the court. And then anytime if someone filed a guardianship, that individual, the potential ward, the proposed ward, has the right to have an attorney in that proceeding. It is a court declaration of incompetency. That's the term that we have in the statute, and understandably a lot of people don't like being referred to as incompetent. It can be a very emotional and invasive process for them. It can take about 3 months, potentially longer. It can be costly. Again, like I said, they have the right to have a jury trial, so it can be contested. And they just have less choice. So the court should be considering what they want and the wishes of the family, but the court's not bound by what the individual wants. So again, hopefully the guardian is acting appropriately. If they're not, there is a safeguard for that as well. Someone has to petition the court to review their conduct. So that's things like self-dealing, if they're not acting in the person's best interest, that sort of thing. So the court has a bunch of remedies. They can instruct the guardian to do certain things. They can actually remove the guardian and appoint a successor. They can order them to pay the costs and fees. They can fine them. And they can require them to reimburse the ward. Any questions about guardianship? So at the Guardianship Support Center, again, so this is a helpline. Our number is down there. So you do have to call and leave a message, and then I'll get back to you as soon as I can. Or email is good too. Our website's down there. I do have a sign up if anyone wants to sign up for the newsletter. I can leave this up here. So I also have cards if anyone wants a card. We do the newsletter every quarter. It goes out by email. So I put a lot of information about changes in the laws, like some interesting cases and questions that come into the helpline. I have resources here as well. So the Elder Benefits Specialist, any benefits questions for Medicare, Medicaid, that sort of thing, they're at the Aging and Disability Resource Center. The Ombudsmen are a great resource. They can be an advocate for individuals. Division of Quality Assurance, if anyone has any issues with facility, with the caregivers, with a corporate guardian, you can file complaints with them. And then one of our new grants is the Senior Medicare Patrol, so I do have cards for those as well. So if you have any questions about your own billing, if someone has called, they say that they're calling from Medicare, there's scams with durable medical equipment or diabetes testing strips, that sort of thing. So if you hear of anything and you see anything that's not right, you can call the Senior Medicare Patrol and they can look into that. Or if you're working with anyone where they have a question like that, someone's asked them for their Social Security, or they got something fishy in the mail, or you see a weird advertisement, that sort of thing. So I have these up here if anyone wants them. And again, if you want to sign up for the newsletter, just come up here and I have these materials.
I get so many phone calls pertaining to Medicare, pertaining to back pain, braces, back belts, knee braces. Can they stop?
Well, here, I'll give you a card for the Senior Medicare Patrol. So definitely if someone calls you like that and you feel that something isn't right, then definitely call and report that.
I get it 3 times a day.
there's people that call to and they've given out a lot of their information. They've given out their social security or their Medicare number.
Medicare wants my Medicare number.
And I don't work with Medicare or Medicaid, but from the other attorneys in my office, Medicare is not going to be calling you. So if anyone calls saying they're from Medicare or they need your social security, then it'd be good to call the senior Medicare control. Yes. Yep, our website has the power of attorney forms as well.
Power of attorney for healthcare, they still would maintain voting rights, correct?
They do.
It would just be with guardianship?
Yep, guardianships, and there can be individuals that have a guardian that can vote. Yep, it depends. They can retain that, but if it's just an activated power of attorney, they can vote.
And the guardianship or a power of attorney for healthcare, and on behalf it would be personal representative, correct?
Yes.
Some people that think they're still in charge, you know.
Yeah, that's a good point. They end on death. There's a couple of situations, like I just had it, for, like I said, the authorization for final disposition. If they didn't name someone, guardian is number 7 on the list. So there's limited times the guardian of the estate has to submit a final accounting, that sort of thing. But yes, people believe that, especially for powers of attorney, that their authority continues, and it does not. It would be the executor, the personal representative named in the will.
So what if they come to a facility and they want to pick up their possessions and they're not?
Everything financial should be turned over to the representative or the trustee.
What if children or siblings would not like to be chosen to be a POA of help or finances? Don't they have to agree your agents or your?
They do, yeah. If someone's not willing, then even if you name them, they can put a statement saying, I'm not willing to act as power of attorney. They're not forced to act.
What do you think of no family members?
You can have friends, neighbors, it does not have to be family. As long as it's someone that you trust, that's going to carry out what you want. Thank you.